Yes, I mean, pardon to make a mention, my lord. Item 86. I am working with HS Mishra here, medical checkup, my lord.
Okay.
You take
कर दीजिए 86.
some copy of the paper documents.
Yes, 86. On the request of Mr. Cheshma.
My lord, item number 7, my lord.
This is under section 378, 376. Custody is concerned is custody from 7/9/2013, more than 12 years ago.
So what is this is a this criminal appeal, huh? Is in custody. Is in custody. Argue the matter. Argue the matter. We will finish it up. Soft copy. You take the soft copy and put it on the second or. I will finish it up. He is in custody, na? Criminal antecedents are called.
My lordship, that was reflected in the judgment itself. And also, my lordship, last occasion, another coordinate bench has asked for about the victim. The victim is my lordship. I have got the report. She has already married. She has 2 children. Yes, staying with her husband.
Okay. Then let us hear it and finish it up, because these are the matters to be heard, you know. They are in custody. Soft copy. Right down. The appeal is ready for hearing. The appellant counsel for. I did on 2nd or 4th. Huh? 4th I'll put it. If it doesn't happen, then I'll consider the bail on that. Okay. Release the matter for release the appeal for hearing. In the meantime, the appellant counsel for the appellant is permitted to obtain the soft copy of the trial court record. You take the soft copy, get ready. We'll see if it doesn't happen, then we'll bail.
Item 2.
Which order you are seeking?
15.5 order. In 15.5 order, minors modified 16.4. 16.4 for bank guarantee. That is okay. For the temple.
You are for the temple. See, the problem is the entire account is seized. Where from he'll get it? He said that I'll give bank guarantee, no problem. I passed the bank guarantee order. But the problem is subsequently found that his all accounts are frozen. How will he furnish
that person minors for the ensuring the bank guarantee funds against that.
Then you have to defreeze that account. You have to defreeze that account. It is frozen. That's what he says. Accounts are frozen.
Yes.
Accounts are frozen.
Frozen just says, my lord. But from the direction may be issued to that 5.9 crores. Maybe you have this temple administration.
The entire account is frozen. You are doubly benefited. Property security as well as that money is frozen.
How can the temple administration, which is not a party to the main petition, how can the IA be maintainable at their instance? And who are they, my lords?
Direction has been issued to.
See the police. Try to appreciate. The police has. I understand. Temple, Jagannath temple. 1 lakh for you is such a big money. 1 crore is such a big.
90 lakhs minors. So that's minor minerals have been stolen, minors removed. But that is the entire.
Who are you? Are you the informant?
Yes, madam.
You are the informant.
Yes, madam. I am the informant. Direction has been issued. I have been deprived. Ultimately, sufferer is the temple minors. The entire quarry revenue minors. That is the backbone of the revenue.
The account has
backbone of the revenue minors.
Account has to be frozen, defrozen.
Account has been defrozen. Year markings 2.9 crores minors. I wouldn't have any objection, minors.
See, if the trial is going on, how can I? How can I decide? See, he may be acquitted. Then what will happen? You never know.
Happening, I have not committed any mistake. The mistake is the temples.
No.
Today, suppose I release 2 crore rupees. to the
Temple.
temple administration.
My lord.
Tomorrow he is acquitted. What will happen?
We will refund it, my lords. We are not spending that money. We are keeping in corpus fund, my lords.
That is, see,
We are keeping in corpus fund, my lords. Ultimately, the temple is losing because, my lords, day-to-day rituals, day-to-day festival, cultural activity,
that money
that depend upon
you have enough-
quarry revenue, my lords.
you have enough money there, no problem.
No, sir.
Can I defreeze the account and part of the money? Can
My lord, I have not frozen it. The
They have-
freezing is not by them also, it is by the
Police.
investigating officer.
Let the investigating officer file an application for defreeze.
My lords, for the last 8 months, my lords, I am without access to funds. Because of two things, my
See,
lords.
the problem is they try
Because of
to.
two things. Number one, my lords, a false FIR has been filed against me, which your lordship was not inclined to pass. I am not on that. But the FIR was because, my lords, when they gave me the query, by then, my lords, other people have stolen it. That is their own officer's report,
No.
which I have annexed, my lords, annexure 2.
That is a very
Sacred
preliminary
property,
stage.
sir.
I can't
That
delve
is
upon
I
it.
have annexed their own officer's report. which
I'll call the
now-
IO. Let us see the IO. If we can
I will give
move an
it-
application for
Well,
defreezing
for
and the part of the
accept-
amount can be given to
For
them.
a
With
sympathy.
an undertaking that will be written in case.
What sympathy can be made given to
Mansala.
people, my lords, who don't deserve sympathy?
Mahaprabhu Jagannath doesn't seek sympathy.
Mahaprabhu
So
does-
my brother, my
I
senior
am not
brother will.
talking of the Lord.
My
I am
lords,
talking of
the-
the Jagannath
my
temple
Lordship, may
administration.
kindly see the
Now
client,
your lordship
the
is-
heavyweight client of my senior, my lords. Heavyweight client. Lordship, may light.
No. See, he doesn't say Jagannath. He says-
Lordship, the late Ramdas Agrawal is a very good devotee of, very great devotee of Lord Jagannath, my lord. He is,
Everyone of us
Yes,
is.
That's being penalized.
because,
I'll issue notice.
because
to
they
the-
remove.
Okay,
Yeah.
I'll just issue notice to the IO. Let us see.
I have-
Find out the way.
My
Find out.
my
the
lord,
way.
some,
Issue notice to the IO.
some maybe.
Let us find out the way. Find out the way. Because he has given the property security. You have no problem.
Property
security-
managers, I don't have infrastructure managers like
Lord,
bank.
what
I
infrastructure?
am only administrator,
What-
chief administrator there.
What will you?
Who will evaluate?
What
Who
is-
will value the property?
I
Who
can
will
understand
say-
if this is the
I am
only money.
giving the valuation
But
certificate by
bank,
the revenue
bank guarantee
authority.
is no problem. Same property may be kept in
His
the bank.
account is
Take a-
frozen. Where from he will furnish the bank guarantee?
Bank guarantee can be issued by pledging the property also, immovable property also, collateral also,
How
in the
can
bank.
it be done?
In the bank.
Why are you complicating
Lordship
things?
I have put a small note for your lordship, see,
Keep it,
on behalf of the temple.
We'll see issue. I'll let the IO come back. Find out.
I'm sorry, I'm
How
sorry.
can I not be filed without a copy?
Give
Right,
a-
I'll not solve it now.
Give a copy.
You are not here.
These acceptable to me.
We will find out. a way.
They are not-
In the interest of Lord Jagannath, you should
is
find
not
some
in-
solution, my lord, my brother.
Paddy Millers.
No.
It is in the interest of Paddy Millers
Why?
who is behind all this.
This
We'll
is very
see.
surprised.
Let the
Why
IO.
necessarily? That's meaning to it.
We'll see how can it be resolved. See, the IO come, we'll see. But I think this is a fair order. It's a fair order. Need
And
not-
if he was fair Millers, he would not have continued with this because your lordships have passed the entire auction. He is now a contemner before your lordships.
We'll see that. How can
That can be done. No problem.
Problem.
item 6 notice to IO?
Next week, my lord.
I'll give a date.
Okay, much obliged. Much obliged.
Yes. 3.
Hon'Ble Das, your lordship, Mr. Das of this counsel of this case is not available, lordship. He is out of station, so lordship. kindly attend this matter.
Yes.
Item 4,
Unmute, Mr. Das.
My lord, item 4, my lord, I am not present, my lord.
Not please. Okay. Not please. Okay.
item 5,
Item 5 में file interim application prayer for extension of time for sorry,
Extension of time.
my lord.
Extension call the time, last and final opportunity, and no further extensions are granted. Extension till आज कितने गला
21
20 15 September.
item 6,
May I please, your lordship? Well, this is, madam, I'm seeking your lordship's indulgence for modification of lordship's order dated 5/4/2025. But before that, my lord, your lordship will allow me to go to the backdrop of the case, because without that, my lord, I will not be able to apprise your lordship what
What
has
is the,
happened.
what
It has,
have I?
it has become a very misfortunate incident which has happened. My lord, let me explain, lordship. These three petitioners before your lordship, father is an 89-year-old man, two sons. Two sons were doing business way back in 2016-17. They come in contact with this opposite party number 2. They do start doing business. Opposite party number 2 wants some money to show his financial credibility because he was involved in ED cases. He had embezzled money and he had duped around 45 people. So he needed some cash, some checks to show them that he had financial stability. He takes 3 crores of check. Then after 3 years, after 2019, he does 2 NI Act cases. NI Act cases.
That opposite party.
Opposite party number 2. In which father is not involved, only the 2 brothers. Notice is issued, they count matter and returns the original checks to the parties because he knows how it was done. After 3 years, he files a 1cc case. 420, 406, 34 IPC, all triable by the magistrate.
Saying what?
Saying what? That this father and son, there he involves the father. The father and son, they have taken away my money. They come to my house rented house in Bhubaneswar. They threaten me on gunpoint and they ask me the money. Surprisingly, he has withdrawn the case after this incident. After this incident, in the protest petition, it is very clear.
After this incident which he narrates.
After that
138 cases withdrawn.
130 was, after that it has been withdrawn. But he says, anyway, that is a different part. He files an 1cc case that is sent to the police 156(3) for investigation. Police does an investigation, gives a final form saying this matter is a mistake. It's a false case. Because on that point of time, the brothers they were in Calcutta. Phone from the call records, it is found that they were in Calcutta. And this man was in Cuttack in Chandni Chowk area at that point of time. The police calls him, he doesn't go, he does not show any material, he doesn't show anything. Fine. So police says that final form is filed and it is good. Then he files another protest petition. In this, my lord, he so moto in such Arms Act, 25 and 27 Arms Act.
In the protest petition.
In protest petition. Cognizance is taken. This comes, my lord, after 19, the 20, the 1cc was withdrawn, and this is in 24. So cognizance is taken and notice is issued. What he does, my lord, he issues notice to the old office address where these people are no longer there. And eventually what happens, NVW is issued. NVW is issued there, the Salt Lake police prizes them, they come, they appear before this Garnet court below, and they apply for 205 CRPC and for dispensing power, which is rejected. After which they came before the lordship in this CRLMC 1002 for NBW was issued. Your lordship stayed the NBW and asked them to surrender and apply for bail on which shall be considered on merit. But here, my lord, I think there was some communication with the lawyer. He probably could not tell your lordship that 25 and 27 some Arms Act are not tribal by the magistrate. So they had to move both the courts on the same day. That order should have been taken, my lord. In case it is rejected by the court below, they shall.
No, that's you may be wrong there. Para 3 of the order, just see. I have written 25, 25 and 20.
Yes, yes.
I have written.
So that is what, my lord, I think the law.
You are now apprehensive that once you surrender,
no, my lord,
because of these 2 offences, you will not be granted bail. That's your apprehension.
No, my lord, what shocking thing has happened, even more shocking thing has happened, which I am very candidly confessing with you, Lord. These people, they are asked by the lawyer to go and surrender. They go and surrender. Their ID Aadhaar card is verified. Then they are on the impression that they will get a bail because they have no idea. They are ignorant people. They're from Calcutta. They're also not resident. So the moment they come out and they're waiting, the lawyer informs them that you will be taken into custody now because the court is not inclined to grant you bail. The 89-year-old father collapses there. So they, with the discussion, my lord, with the discussion with the lawyer, they come to a conclusion that we will not press this petition today. You take your father to the hospital. The moment he's
What do you want now?
Well, let me finish. Then your lordship, whatever your lordship will pass, I don't have. Then they go away seeking that clinic also, they take the father. He's admitted to the ICU immediately that day because he's a heart failing patient and see. What happens, my lord, when they go away, the lawyer probably, I'm not complaining about any lawyer. The court finds that they have absconded from the court premises and revokes the NVW and files a case and directs the police to register a case under 62 BNS that they have absconded from the court premises. This is how it stands now. Now, my lord, I filed one quashing of cognizance by the father because he was not a party to it, and I filed quashing of protest petition in which I have been protected by this honorable court. 2 coordinate benches have protected me. Your lordship may see 3 orders, 3 cases have been. NVW has been kept in abeyance by
The NVW
now. No coercive action. NVW is kept in abeyance. The matter have.
what extend the time for
But
surrendering?
my lord,
And I'll say that on the same day your bail application should be decided. That's all. That's the.
my lord, that is true, my lord. But my lord, if the first and second hour can be done, because unless it is done, my lord,
Okay, first hour, second hour, how does it make difference? I'll pass that order.
because
First hour, second hour also.
I don't know, my lord. I'm before a lordship. It's a mercy petition.
I
My
understand
lord,
it.
now.
The only solution by what you told me, the fact which has unfolded now, the only thing what I can do is I can extend it for, and I'll direct the court below to decide your application on the same day, first hour, second hour, whatever.
But my lord,
That's the only thing.
can't I pray for a bail, my lord? Because now
Bail jurisdiction is not with me.
no, they will come. No, my lord, you can because these are all magistrate tribal cases, my lord.
This is-
Only except
Modification or otherwise, I can extend the time for surrendering. Meanwhile, I'll give you liberty to move before the High Court for bail, anticipatory bail, whatever. I am today. I am looking at this my order. What modification suits you?
no, my lord,
I can only modify to that
my lord,
extent, not beyond that.
my lord, let me tell you my.
Well, you
predicament.
tell me what modification you.
Why I was not able to come before a lordship for modification is because partly this was complied. So I did not know how to come before a lordship to ask for a modification.
The problem is you pursuant to my order, you went and surrendered and escaped from the court.
Yes.
Court itself.
So that is
So this order goes basically.
so
This order is already complied.
my lord, that is why I'm
True sense.
honestly, candidly confessing, my lord, what
If I record the conduct of you, then you are gone.
I know, my lord. I know, my lord. But I have also written that in the petition, my lord, because they were not aware of the intricacies of the law, court proceeding, my lord. They are not ignorant about law, but that surrendering and all those things, they were not aware. So when they were under the impression that once they surrender and the matter will be not pressed and they will come and again surrender in another date.
I'll issue notice on the application. Meanwhile, you think over what.
My lord, I'll think over. Your lordship will give me some time to think over. I'll
Just
discuss
issue
because
notice.
it's an 89-year-old man who has
I
nothing to
understand
do
it.
with this
I
one.
understand the problem. I notice to who is there?
Copy number 2 is there.
OP number 2 and Mrs. Sarita Maharana accept notice. Accept notice. Signature after 15 days any time. Meanwhile, the petitioners are at liberty to resort to any other remedy available to them under.
I'll come again before a lordship.
I
after
see what
taking-
this is a
Your lordship dispose it-
purposefully I am doing it. I have issued notice. I kept this application pending.
Yes.
Meanwhile, I am giving you liberty to resort to remedy available to you under law,
Yes.
so that you can explore some possibility. If it doesn't happen, then come here.
I'll do that.
Both the things I kept it open. Okay.
Because it's
20 days for the day 2. It's Sarita Maharana accept notice for the state. Opposite party. Opposite party number 2. In the meanwhile, during the pendency of the application for modification, the petitioner is at liberty to resort to any other remedy available to them under law. Do it.
any other remedy, my lord.
Whatever, many remedies are there.
No, my lord, what
I'm
no,
not
my
seat
lord.
of advisory jurisdiction.
No, I
You
didn't-
have another experience. Now you can do
I
that.
was only wondering, my lord, if I need to surrender in the meantime and apply for bail, I'll take it on the other
Then
day.
I have to dispose it up.
No, then I'll take it on a different day.
That's the reason you try it. Because see, this order has already, my order has already been complied. You went and
Partly-
surrender.
Partly
Not
compliant.
partly, fully. You went and surrender. When the order that's going to take you into custody, you
Yes,
run away
yes,
from it.
precisely,
And
precisely.
thereafter, NVW is issued now.
Precisely, my
And
lord.
that
Yes.
NVW is subject matter of another petition.
Yes, my lord.
So how, if I modify and everything goes. So therefore, I will simply issue notice.
Send the
I give you
complications,
the,
my lord.
what you do, you know what to do now. You know what to do now. Just, I keep it pending so that this should also be, in a sense, sub judice before this court,
Yes.
this order.
The-
So the
Let him
effect
appear.
of, the effect of the order is to some extent is nullified.
Yes, my lord.
So in
Obliged.
meanwhile, you can go and try.
Obliged, my lord. I'll wait for your lordship's.
So that liberty I'm giving you.
Obliged.
Yes.
So let it come,
And name,
16th of September. Obliged.
name should reflect
Obliged.
this. And cause list also, name. Yes.
Item 8.
My lord, in previous date, your lordship directed the petitioner to issue notice to the opposite parties. Hence, I have filed the requisite to issue notice.
You let the extra copy notice service है ना? Service notice. Hmm?
State only is
State.
state service.
What are the offences?
Offences, my lord. Mm,
Yes. What do you want?
My lord, your lordship has passed the order on, in previous date, 14th May of 2025, my lord. He shall be released subject to verification of a similar type of antecedent, if any. The lord.
Yes.
the-
Find out.
My lordship, the fear of the petition.
In
Here said,
In the application.
Yes.
Yes.
Here, saying fact my lordship FIR has been lost. And again on 1 is 2018, again on 2017 also there was one FIR with the same cause of act. For that they will make a modification, they want to know whether 2 FIR can be lost against the one person. only.
This is not the jurisdiction, madam. You would file a 482 petition.
Where we can't.
My lord, in the same cause of action, one GR case is pending, and another case is the check bounce case is running before the JMFC 1. My prayer before lordship is that if check bounce case is running, another GR case under section 406 and 420 IPC offense will never be made for the decision of the Mohendra Bhai Patel.
Madam,
Sangeeta
Madam,
Mohendra Bhai Patel.
yes, you are correct. Maybe you are correct. I am not examining because I was dealing with your bail application.
Yes,
I
madam.
granted the bail.
Yes, madam.
In the modification, I can't do only deal with these things. You have to file a specific 482 petition raising all this point. I will give you liberty to file a 482 petition.
Yes, madam.
Right. The modification application, the petitioner has moved the present modification application inter alia praying as under. I'm afraid the modification application, the modification application seems to be a petition, a to petition in this guy. Therefore, I am not inclined to entertain the petition. However, liberty is granted to the petitioner to resort to the remedy available to them under law, including filing for yes, with this observation. Yes, sir. Yes.
Item 9.
Please, my lord, in this case, I have filed a review petition for review of the earlier order of my lord, that is 6/1/2005.
Which order?
6/1/2025 for
Yes.
restoration of CMPL. I had filed CMPL 463 of 2024, which has been dismissed by my lord on the ground of delay of 1833 days. Subsequently, division bench or order of this honorable court is that in that case, I have annexed, that is annexure 2. More than 3,000 days has been condoned, my lord, 3,494 days. I pray sympathetically maybe petitioner's case may be subject to some cost, my lord.
No, see, I have rejected your application on the ground of delay.
My lord.
Okay? You are now citing some other case where delay was condoned, more delay was condoned with God. See, there is no parity because delay is
My
you
lord.
have to give sufficient cause. I don't know how in what ground the delay is condoned there. The only remedy is to go somewhere else, not the review. I don't know on what ground the delay was condoned in the other matter with the cost of 1,000 rupees,
My lord.
isn't it? What was the delay in that case?
That case was 3,494.
That is also not coming forth in the record.
In
Where is
view
it?
of the above delay, that is in para
No delay.
3.
In view of where are you reading?
Page 21, my lord.
Lecture two.
That is CMPL 430 of 2024, para 3. In view of the above delay of 3,494 days in filing the
But see, I don't know what was the sufficient cause there. What was there may be sufficient cause must be there. You have to go somewhere else. Right up. The petition in the present review petition, the petitioner is seeking recall of the order dated, recall of the recall of the order dated 6/1/2025 passed in CMP APL number 463 of 2024, whereby the CMP was has been rejected by this court on the by condoning the delay of 1833 days. The court found that there is no sufficient cause shown to explain the delay of 1833 days. Accordingly, the petition was dismissed. The letter counsel for the petitioner by citing the order dated 15/1/2025 passed in CMAPL number 430 of 2024 submits that in the division bench of this court in the CMAPL number 4 of 2024 to condone the delay of 3,494 days by imposing a cost of $10. Hence, he submits that in the present case also the delay of 18 days ought to have been condoned with subjecting the petitioner to cost. From the record, it is not coming forth as to on what ground the division bench had condoned the delay for 3,494 days. Moreover, condonation by the court, condonation of delay is on the duty of the sufficient cause being shown by the petitioner. There can't be the order of the division bench cannot be treated as a precedent for condoning the delay in the absence of the cause shown by the petitioner before the division bench for persuading the division bench to condone the delay. I'm not inclined to entertain the review petition. Accordingly, same will discuss. Yes.
Item 10,
May I withdraw? In item 10, the petitioners, they are the retired employees of All India Corporation, Your Lordship.
Sorry?
The petitioners are the retired the petitioners are the retired employees of All India Limited, Your Lordship. Their limited prayer is for pension, and so far as they've signed Aisha 4, wherein the All India Limited, it has rejected their prayer for pension, stating that at the time of your reappointment, you have signed an agreement that you will not be entitled for pension. Prior to taking the impugned order, Your Lordship, This is Annexure 1 at page 15.
Annexure?
1, page 15.
Yes.
It states the Burma Oil Company acquisition of shares of Oil India Limited and of the undertaking in India of Assam Oil Company Limited and the Burma Oil Company India Trading Limited Act 1981. After the acquisition, on the same day, this MOU was framed, Your Lordship. At page 21, Your Lordship will see chapter 5.
Page 21.
Chapter 5, it states provisions relating to employees. Transfer of service of existing employees of the specified companies. Every full-time officer or other employee of a specified company who was immediately
All these companies were
amalgamated, merged
Yes.
together, Your Lordship. And so far the present petitioners are concerned,
Subclass 2 of that, subject to the rules made in.
yes, Your
India.
Lordship. One is also vital.
22,
Once
3.
one says, once the company is being taken over by the government of India, from that date onwards, they're deemed to be the employees of the central government. 2 says, their condition of service will not be detrimental to their interest. It will be the same as they were enjoying prior to that.
Acha.
And so far as at page 22, the Provident Superannuation Welfare Fund states the share which they have invested prior to the acquisition will be transferred to the new organization. On that basis, Your Lordship,
Where is the part 22? Which
22
rule?
page as para 12, Your Lordship.
Yeah.
Provident Superannuation Welfare Fund, etc.
Hmm.
Where a Provident Fund, Superannuation Welfare or other fund has been established by a specified company for the benefit of the persons employed by it in connection with the undertakings in India or for the benefit of such persons and persons employed by Oil India, the monies related to the employees. A. Whose services are transferred by or under this act to the government or the successor government company or the as the case may be continued with Oil India. At this juncture, Your Lordship,
Yes.
I was appointed, I'm sorry, I was appointed way back in 1979.
How many of you are there? 5. 5 of you.
Yes, Your Lordship.
Who is appearing for? Yes, sir. Yes.
And we have to counter. Specifically stated that while taking temporary appointment, they are approximately kindly come to page number 15 of my counter.
And 6. Which paragraph?
Paragraph running page 60. It is annexure. AC.
Yes.
You shall not be entitled to the pensionary benefits on retirement of the retirement benefits.
Where are you reading?
It's 9, page 16, 9, paragraph number 9.
Temporary employment.
Temporary employment is 15, next page 16. Paragraph number 19 may guide you. 9.
Running page, you tell me.
Running page 16.
No.
It's the internal page.
Starts from 65. 65. 65 to 75. Thereafter, that way. It's 65 onwards, you are counterfeited.
If I may be permitted, I have enclosed my reappointment in my petition. This is page 31 of the petition. Page 31.
I understood your case.
Madam.
There is a statutory amalgamation. And the provision says that the past service and everything will be counted for this. And the pension scheme also, it will be transferred. That is the scheme under the act itself.
About
How they are distinguishing, let us see.
So that I usually counter.
Yes.
Counter affidavit, annexure A by A which.
Your annexure A starts from 76 to 84. Which page you are showing it?
it's page 31. For my lordship, for my present serious convenience, I have enclosed that at page 31 of the petition. The order of appointment.
Let him show you.
79 university can.
79, yes.
79, paragraph number 9.
Para?
9. Get it. 79. It was not 79.
That must be 80, huh? You shall not be entitled to any pension on retirement or the retirement benefit, if any, will be determined by the company's rule.
As may be applicable from time to time. In case you agree to this temporary agreement, accept the terms and conditions set here in court. Please sign and return the duplicate copy of this letter to use the token of acceptance of the said temporary agreement together with attached employment of.
This is initial appointment,
Yes, that was in 1982.
82 appointment.
Right.
Okay. Yes.
And the same thing happened in other cases also.
Okay, one example you have shown. Yes.
In similar cases, all the cases, these are the conditions.
Yes.
Just being highly spoken.
They continue with this condition?
Well,
Yes.
now
Then
we
you-
can come back and because.
That's the only case you have. You say that the initial entry is like this with this
Right.
condition, even if it is amalgamated, the statute says that the whatever the position that will continue.
Right.
So therefore, this position continues even after amalgamation. That's what you are saying. That's it. Yes. Yes. In rejoinder, what have you said?
Yes, Your Lordship.
If this is the condition, as it is, you have been shifted to the amalgamated company, and the condition carries. That's what his case is. How will you come out?
Yes, Your Lordship. Your Lordship may have already, I've already seen the statutory provision so far as the amalgamation is concerned. So far as my Lordship, I have signed that agreement. I don't have any bargaining power with the employer. Because if the,
But
because
see,
I
this,
have.
this continue up till amalgamation took place.
Yes, Your
Amalgamation took place when?
In 1981, Your Lordship.
So you can't be betterly positioned now. This condition remains with.
Yes, Your Lordship.
See, let us see the acquisition.
Yes, Your Lordship.
Acquisition.
It's Annexure 1, page 15. So far as I am concerned, page 21.
Yes. 21, I read it.
Yes, Your Lordship. That's why it clearly says every full-time officer or other employee. It doesn't put an embargo on me to receive the pension, Your Lordship. And on basis of an agreement, Your Lordship, they cannot take away my right of getting the pension.
This act came into force 1981.
Yes, Your Lordship. 14/10/1981.
Your appointment are
Prior to that, 1/4/1979,
79.
my lord.
Yes.
And so far as the position of law is concerned, Your Lordship, the Honorable Apex Court in the case of water.
No, after 23rd September 1991,
My
you
lord.
have been working in the amalgamated company. Your qualifying service is satisfied for the purpose of
Yes,
pension?
Your Lordship. What they have, I was continuing the oil company. They have disengaged me and again re-engaged me on the same date.
But
The hiring-
engage in the new company.
Yes, Your
From
Lordship.
that day, if it is counted, even
Yes,
then
Your Lordship.
your qualifying service is satisfied.
Yes, Your Lordship.
Satisfied.
Yes, Your Lordship.
Was there initial appointment of?
You have disengaged the earlier entry level conditions. Condition excuse that day. You disengaged and engaged in the new company. From that day, at least their qualifying service for the purpose of pension will recon.
You see the, so they are not giving the initial date of appointment letter. This is all after acquisition. You know, we can see the annexes. This is all after 79.
Your Lordship, the
After
The reappointment
acquisition was there. Appointments are given and next to the retirement is all after,
Yes.
not prior to that. They should have given that.
Where is the disengagement?
page 31, Your Lordship.
31. Okay. Let us see 31. Yes.
We refer to your application dated so and so and to a subsequent interview with us. Pleased to offer you clerk in grade 2 clerical program in our organization with effect from so and so. Please note that your temporary appointment by us letter dated so and so stands terminated.
And with effect from 2/1
1982. They have again re-engaged me.
re-engagement. Yeah, re-engage. In all the matters, re-engage.
Yes, Your Lordship.
Same day,
Yes, Your Lordship.
2/1/1981.
My Lord.
2/1/81. And at least from the 2/1/81, their
If it-
service
if it
has
come-
been reckoned for the purpose of pension.
The company itself sorting up Mr. Prithviraj, and
That I have seen.
Yes.
That I have seen.
And with regard to that signature.
Yeah, what do you say?
You could also see, they, with what they have annexed to us, that is of 2081,
See-
not 1979.
See, you have a case or not? Unnecessarily don't try. Because you sought an opinion from Mr. P.P. Rao. In service law, he was the authority. You got an opinion against you. Now, court, and they are relying upon that opinion also.
They're not giving any, my submission is that not giving any initial letter of appointment letter. All are after 7 days. So my case is that since they were temporarily appointment, so therefore, why?
But you have observed them regularly after recalling those orders. From the day when you re-employ them after the Amalgamation Act came, 82. From that day you recon. The qualifying service they will attain.
Previous appointment, they have not given. They have not before also with regard to the previous appointment letter. And there been any letter with regard for 7 days, then I have known this. All appointment they are showing after 81, 82. Amalgamation was made in 79.
No, but the series which you have filed, A series which you have filed,
This is calculated with
1980, 80,
22/4/1980.
March 81,
82,
82,
81.
81, July 81.
82,
81 and 82.
82, yes.
All in your initial appointments are 81 and 82.
That is prior to 14/10/1980.
Right to
14/10/1981.
40, 10, 91. No, there are 81, 82 appointments are also there.
Yes, Your Lordship.
82 appointments are there after the amalgamation.
Your Lordship, may I kindly start with Annexure 2 series page 26. I've given all the re-engagement order issued by the OP number 2.
These are not re-engagement. This is temporary employment.
Yes, Your Lordship, kindly see.
By
Yes, Your Lordship.
All India, 31 December 1980. First one.
First one, yes, Your Lordship.
Yes.
1/1/1981.
28 March 1981.
This is all prior
Second
to
one.
the amalgamation took place, Your Lordship.
No, there are 82 also. The third one is January 20, 1982.
And this so the past starting when they entered, that document is not there.
What is
After counting of services.
Do you have that with you? When you are exactly?
The only difficulty is, Your Lordship, was all prior, it was all the documents are relating to the prior appointment with the earlier company. That's
You knowing when you got appointed?
yes, Your Lordship, I've stated in my writ petition. Candidly
Where is
stated.
that? Where is that? Let us see the writ petition.
My
Where
Lord.
Where have you said that when all of you, all 5 of you.
Paragraph
appointed?
5, Your Lordship, page number 5.
Para 5.
Yes, sir. That is pertinent to mention here that prior to nationalization, that is 14/10/1981, the All India Limited had appointed 25 employees on temporary basis in its Bay Exploration Project office at Bhubaneswar between 1/4/1979 to 15/9/1981, and there was no uniformity of appointment.
This is found to be wrong because see, he has filed a office order which is 1982.
It's regard to the re-engagement, Your Lordship.
No.
Not
Just
the
read
initial
that.
appointment.
Read that.
My Lord.
It's not re-engagement. 1982 order.
Which page? Sorry.
Just come to series A series. A series. A series.
Page number 2.
A series. One of the orders I'll show you. One of the orders at page 17.
It is 30.
January 20, 1982.
My lord.
Temporary employment, Oil India Limited. SK Chaudhary.
It is after the amalgamation, your lordship. That's what I'm stating. It is after the amalgamation. But the present petitioners, they have already been appointed prior to that.
So that is what he says. Give the date when you got appointed or the first time appointed here. That's his objection is.
My lords.
You find out that that's a
My
file
lord.
affidavit. Yes. Right. Right on. Then counsel for the seeks an adjournment to give the initial date of appointments of all the 5 appointments, for all the 5 petitioners, by elaborating the contention raised by them, raised by the petitioner in para 5 of the petition. Para 5 of the petition. Leave the matter 2 weeks for them. Yes.
Much obliged.
Then we can coordinate with.
My lords.
Yes. Yes, next. He'll give it.
Sir.
He'll give it. Yeah,
I am for the opposite petition number 1.
yes.
Yes.
Alive. Fighting in the yes. Yes.
Item 12.
Not.
Huh?
Not. Status was not received.
Yes, madam?
Not received this time.
Not, oh, so you have not got the first report. Huh? ये मेरे को रोक एक कुछ करिए yes, not received. Yes.
Item 13.
Unlike my lordship, I received the status.
Received.
Yes.
Give.
Item 14.
Not received, my lord.
Not
14
received.
and 15.
Not received. Yes. 15.
Item 16.
Like my lordship, I have already received.
15 कोणाला?
16.
16 you have received. Yes.
May I be pardoned, Your Lordship? I'm appealing on behalf of Abhijit Patnaik, item 16.
1 minute.
My
madam.
senior is in
15.
bereavement.
What is the report? 1 minute, madam.
Shiva, alive, my lordship.
Both of them.
Yes, my lordship.
Both of them. Yes. 17.
17.
My lord. Seventeen, my lordship, not received.
Not received. Yes. Not received.
18.
18, I have received, my lordship. Now he is working as a government teacher.
Acha. Alive, huh? Yes.
19.
19 also I have received, my lordship. He is working as a driver in the
Okay.
government hospital.
19. Give that report.
Yes,
Huh?
my-
Yes. 20.
20.
20, my lordship, I have received. He was alive.
Alive. Okay.
Yes.
Yes.
21.
21, my lordship, I have received. He was alive.
22.
He is alive. He was alive means he was alive at some point in time. You say he is alive. Yes.
22.
22.
22, my lordship, having a tea stall. He has a tea stall and goes.
Yes.
Here I am appealing as amicus curiae in this appeal for appellant. I think the conviction was for 10 years. The period which he has undergone, it will be access to the.
So that
Just
is-
check it up from here only. See, can't I say everything is here only. You have to spend little time. And my the supporting staff is there. Just support.
Actually, sir, I'm like the network control. 11.
But it is 376.
So you, if you do, your junior will learn.
We have, but this technology is really tough for us.
But we'll help you. Try, otherwise your junior is there.
Yes.
It is actually junior's job,
Yes,
basically.
ma'am.
Juniors
That
come
is-
and do it.
Yes.
I have been telling you. See,
No.
senior councils, they have other.
Things have been changed nowadays actually.
Uh,
Earlier, my lord, everything was manual and we are always close to senior. We
But
cannot
now
do it.
the reality is you have to
Yes, my lord.
definitely
Nothing can be-
learn it.
Can do-
Check it up, huh? Check it up.
My lord, otherwise let it come on next week, so it can be disposed.
I'll adjourn it, no problem, but inside let him check it.
I'll check up, my
Yes.
lord. properly.
You check it, your junior has to check it. You check it up and tell Mr. Shobhata. Okay? Okay.
He is, oh, 3762A, the child, and the victim is only 6 years child.
It was
So it was proved also.
That's on merit, let us see. The merit, merit.
also all on merit, my lord.
Likhi, oh, what would date be though? Take.
Well,
Yes.
can you-
You give your convenient date so that.
Yeah, my lord.
No. Adjourned, but meanwhile, the junior has to
Yes,
find
we
out.
gather information, if he has covered 10 years, then
Yes.
there is no purpose.
Yes.
The total conviction period 10 years.
10 years.
Yes, ma'am.
Let us see.
Yes, ma'am. Well, oblige, ma'am.
Yes.
My appearance may be noted here.
Appearance and his name should be,
Yes.
name is there.
Yes.
Okay. Appearance.
Appearance.
Shogat Das.
Yes.
Shogat Kumar Das.
Shogat Das, my lord.
Kumar. you can-
Kumar wrongly mentioned. Oblige, ma'am.
You. Kumar.
23,
23, my lordship, father was dead, my lordship, and son is alive.
Died.
Yes, one appellant is dead and one is alive.
Okay. Report received. Then appeal number 1 died, awaited, and so on. Acute await you can call it. Also to paragraph duty abatement also. Yes.
24,
24, my lordship, I have given the report, alive, my lordship.
Alive.
Yes.
25,
But I think it's a vigilance.
Yes. Report was short?
Yes.
Report? No. No report. No. No report. Yes. Vigilance case. Is it vigilance?
7, 326.
Check.
At the time of filing of the appeal, you were in custody. Just take it up. No. 326, 307.
Yes, my lordship, I will check.
Report not received. Yes.
26,
This is not received, no.
Not received. Yes.
27,
27, my lordship. I will receive the report, that's all.
What's the report? Dead or what? Person to the order dated 17/7/2025. IAC Garuda PS has filed a report. As per the report, the sole appellant Prakash Chandra Sahu has expired 15 years back. That is the 15 years back. In the absence of any application filed by a for the Olas of next print under section 394 CRPC, the appeal cancelled. The paragraph in the absence of any application by the Olas or the next print of the deceased appellant, the appeal stands admitted. Yes.
20,
28, my lordship, I have received only the, this is the jail custody, nothing else. Jail custody report, nothing else.
Jail custody means?
He was undergone how many months, that much time. This was-
Now he's in jail.
No, he was released now.
2 months undergone. No, you have to get it from the local police. Local police report. Complete report is not. Yes.
29,
29 and 30, I have not received the report. my lord.
29, 30 not received. Yes.
31,
31, my lord.
Not received, my lord.
Let us see the report. first.
Not received.
Not report. Report hasn't come. Let us wait for the report. Okay.
32,
Received, my lord. Yes.
What is the report?
Not received, my lord.
3 appeals. All are regarding 32. 32. No. Yes.
33,
33 report is there, my lord.
What report?
Along with the death certificate.
Died, huh? Both of them are died. What?
One of is living and another is
Kamala Godia died, huh?
Sadashiv Gardia died.
Working. Kamala today is alive. Sadashiv Godia. As per the report, Sadashiv Godia, appellant number 2, expired in the absence of any application under 394 by the LR or the next friend of the appellant. The appeal stands awaited. Qua appellant number 2. Yes.
34, 35.
34,
File is not there, my lord. So
No report? No report, yes.
35,
no report, my lord.
No report, yes.
36,
36 also no report.
No report, yes.
37,
No report.
38,
161. No report, my lord.
39,
39 report is there.
Living both. Yes.
Both are alive, my lord.
Yes, well.
40,
45 file is not there, my lord.
Report is not report.
no,
No report, yes.
41,
41 also no report.
41?
41 no report.
Do you have any idea?
ମୋର instruction ହଉଛି 1 ମରିଯାଇଛି ବୋଲି ବାକି ତକ ଅଛନ୍ତି କିନ୍ତୁ ଆସୁନାହାନ୍ତି ସେ ଯୋଉ advocate ଦେଇଥିଲେ ସିଏ ବି ମରିଗଲେ
କେତେ ଜଣ ଅଛନ୍ତି? 4 ଜଣ।
ରିପୋର୍ଟଟା ଆସୁ
ନା report ଟା। What are the offense, Mr. Mishra?
302 ହେଇଥିଲା 304 2 ରେ convict
ଦୁଇ ହେଇଛି, okay.
RI for 4 years.
42?
42,
42 also no report, my lord. 306 IPC.
No report, yes. 40.
43,
43 file is not there, so report.
No report. 44?
44,
44 report is
44 which matter? This is 130. 130 report.
130 report is there.
130 day. Recapitulate or something.
It's 130.
Rabindra Kumar.
129.
130, yeah? 130 level. Appeal number 130. Appellant number 1. Rabindra Kumar Patra expired on 19/9/2021. 21 in the absence of application so and so abated. Sub item number 129 रे केतरा appellant असंती?
Death certificate.
No, single appellant. The sole appellant. Sole appellant Gundicha alias Rusikesh Behra has expired since last 4 years. In the absence of so the appeal, the entire appeal stands 129 Kurata. 130 abate हुआ 1. ठीक है. Yes.
45,
45 sole appellant died on
Sole appellant
died.
Sole appellant 14 died. Sole appellant तो देखिए तो Sole appellant Suvendra Kumar. Suvendra Kumar Acharya has expired on 6/9/2020. 14. Okay, in the absence of so and so, abated. Yes.
46,
46 no report.
No report. 47.
47,
47 also no report, my lord.
48.
48,
48 48 report is there, my lord.
Yes. Alive.
Alive, my lord.
Alive. 48 to get the report. 48, 52, all report you have given.
My lord.
52 is
48 report.
42, 53, 60, 101.
48 48 49
49 no report.
no report.
50 and 51 also no report.
No report.
52 is
51 also no report.
52 is there.
52 is this the report. 52. Let us see. 52 report is affluent. Sole affluent, huh? Right.
Turnover 49.
No report. 52 is on bedridden, my lord, and not able to work.
Report.
Not able to work.
The sole appellant, although he is alive, but he is suffering a prolonged illness due to old age. Due to old age. 52. Well, take it.
Bedridden and not able to work.
Not even able to walk. Take it.
Right, turnover 49, I am appearing, my lord.
My lord,
49 report has to come.
my lord, may I submit, my lord?
Yes.
Audible? Item 48, my lord, associates is there. This is a case of criminal appeal against this.
Report has to come.
No, report is there, my lord.
48 report has come.
Yes. So what I am praying, my lord, the similar nature of issue has been dealt with before with the coordinate bench and passed in judgment, passed in order acquitting the persons. So I am placing the same for reference only. Different issue, and Lordship will educate on his own merits.
Fourth, you get that judgment fourth.
Fourth,
Fourth
yes.
of fourth. Fourth. Keep it.
Yes. Obliged.
53 9.
I also submit the debt chart synopsis and note of submission.
Yes. And we will finish it up that day.
Yes. That's why I am saying, madam.
Yes.
It will expedite and it will.
Yes.
53. 53, 60 and 101.
Same, na? 101.
Same.
60.
1 minute.
60.
Adi wo koi the number na kho.
48.
53, ma'am.
53.
60.
60.
101.
101. All the list it on 4th. We'll fill it. That report okay. Prepare the short synopsis kind of thing.
That's also.
54.
54 instruction is there, my lord. Appellant 1 died.
Report name. Yes.
54 instruction is there. Appellant 1 died, my lord.
Who is that?
Kuntala Sahu.
Kuntala?
Sahu.
Kuntala Sahu died, huh? Appellant number 1 died. Huh?
1 died.
1 died.
2 alive.
54. 2 died. 2 is there. Kuntala died. Stand evident. 2 remains. Okay. Thereafter 55.
No instruction. 55 up to 59, no instruction.
55 to 59. No report. 60.
60 instruction is there.
56 is the CBI.
60.
56.
56.
7 months conviction. At the time of filing of the
Report.
appeal.
What was the age?
67 in the year of 2010. More than 80 years.
CBI, nobody there. I called for a report. Do you have any idea whether he's surviving?
No, lordships, I have no idea. At the last occasion, your lordships.
What was the
Report ta CLA sorry jata.
CBI case?
My lord.
अच्छा स्टेट को मगा जाइतिला 56 लेको दी स्टेट लेखा जाइति सेति पे प्रॉब्लम अछि स्टेट को मगा
Whereabouts mogaitla.
हां the by order dated 20 5/7/2025. Report of well-being and whereabout of the appellant was sought from the state, from the state. Our letter counsel for the state submits that the case prosecuted by CBI. CBI. Hence, which CBI this thing? Where was it registered?
My lord, the permanent resident at West Bengal, Bardhaman. And at the time of occurrence, my lord,
Which police, what do you call, where the FIR was registered? Raulkela, CBI Raulkela. Okay? CBI Raulkela, SP CBI Raulkela is directed to submit a report. By on the next date, given. 57 is not there. 59th of 9, 60. 60 is there. I don't know. 61, right?
61, my lord, no instruction.
Yes, I don't think so. Yeah, right. Appellant number 1 has expired on 22/7/2020. In the absence of any application under section 394 CRPC by either the LRs or the next friend of deceased appellant, the appeal stands abated. And so far as appellant number 2 is concerned, he is at present 70 years of age and
staying at
suffering. He is suffering from old age ailments. 60.
My lord, in item 43, my lord, I may be.
I will not go reverse. I have passed the order. Just check it out.
I may be permitted to take the PCR, my lord.
You can take it, no problem.
62.
Be confusion. Yes. 61.
61 instruction is there.
61 is there. Report is there. Report. What is in 61?
That is wrong instruction, perhaps, sir.
What is the writing? I don't know.
Deputy Commissioner of Police has written that is wrong instruction has been given, my lord.
No report.
No report.
What kind of report? Just see. 62. No, not complete. Yes.
No instruction.
62.
62 report is there. Could not be traced, my lord.
62?
62 could.
Could not trace out the information. Could not trace out means you have to trace it out. The report dated, report submitted by the circle. You get it from jail authority, you will get it the same report.
Yes, ma'am.
The report from jail authority, circle jail, Sambalpur has been placed on record. He has intimated through this report that the whereabouts of the appellants are not known. In fact, the direction was issued to the state government to obtain instruction from the local police. Council for the state seeks one more opportunity to obtain the instruction. Obtain the instruction.
Appellant is at 94 days. 94 days. Appellant.
Appellant is?
94. Is it about 94?
62, item 62.
62.
94, these people are not able to get the information. You are asking from jail authority.
Yes.
These people are on bail. Why are you asking from jail authority? You would ask for the concerned police station.
No, from jail authority also from IAC.
You need not ask for jail authority because none of them are in jail. All of them are on bail.
Also, we
They're
have
on bail.
written to IAC also.
Is on bail.
IIC report has not been received.
Not there.
Get the report. Yes.
63,
63 no information.
No report. Yes.
64,
64 also not report.
65 there is a report.
4J. No.
65 there is a report.
Five.
Where? The report it says that there is no village at all in the same name. What kind of
Item
First type of
65.
village, Malapalli.
Maliapatti? There is no village in the name of Maliapatti.
It's in the district of Srikakulam, Lordship.
Srikakulam, Malia.
On the last occasion, Lordship had directed.
T.S. Raukala, D. Sundargarh.
ସେଇଟା ହଉଛି ତାର ଇଏ ଥିଲା permanent address.
See, it is written Maliapatti, and he is given a report that Malapalli.
Malapalli. That is wrong.
What is written this in the cost title? Just see.
Yes.
Cost title. Malipatti, Malipatti.
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 And this
Malapalli लिखले पड़े.
come and
They are searching another village. Pursuant to the order dated 31/7/2025, a report has been received from IIC Tangarapalli, PS Raulkela, entry stating that on verification they found that there is no village named Malapalli. Malapalli in Sundargarh district. Srikakulam लिखा है सुंदरगढ़ कुछ जगह. Report appears to be a complete non-application of mine. Cost title of the address of the sole appellant is given as Malipatti, M-A-L-I, Malipatti, PS Malipatti, District Srikakulam. District Srikakulam.
Which time is given?
Tangarapalli. Apart from the address at quarter number C/80, construction colony, PS Tangarapalli, Raulkela, Sundargarh district. Sundargarh district. This it appears that the construction colony means some construction might be going on. That time temporarily the IIC PS IIC Tangarapalli PS Raulkela is to file this press report. That's it.
Okay.
Yes, now hearing.
66,
This is I have reconstituted the file. I have obtained the LCR from in the pen drive. There are 700 pages. I will go through it. I prefer a week's time. I will prepare a note and.
Okay. Appellant submits that he has obtained the copy at the trial court record. He will be preparing a solution of this and submit.
item 67,
Item 67, 4 appellants were there, but out of 4, 214 already dead. Your lot will here, appellant number 1 and there are.
Who has died? Appellant number 2 has died.
2 and 4.
2 and 4.
2 and 4 has died. Yes. Since so far as the other appellants are concerned, 1, 3 and 1, 2 and 3.
4, 4 to.
1, 1,
1.
1 and 3.
1.
1 and 3, yes.
So my appellant with a conviction.
What is the offense, madam?
They are convicted under the 15 of the NDPS Act. I was sentenced to undergo RI for 3 years.
10 years and fine of 1 lakh rupees.
For each. And during the pandemic of that, 2 persons has already died, and then 1 and 3 were also. The prosecution story is not the same. On by 22/2/94, night PW8 Safety Inspector of.
You have paper with you? The evidence is there with you? Take out the files. Just take it out. I'll just come within 5 minutes. Take it out. Yes.
The lordship permission, 2011 matter,
Huh?
2011. Appeal,
No, what happened?
listed.
That will be listed. Why do you worry?
No.
When your matters are listed, it's not convenient, you don't come.
No, no, it is.
When
Your lordship.
somewhere you got the right instruction, you come.
Your lordship is hard the matter.
Huh.
Before the one sitting sing. ଶୁଣି ଯାଇଥିଲେ ଏ ପାଠାଡେ ହେଇକି ଥିଲା ଅଛନ୍ତି।
We'll see. Yes. Yes. Yes, madam. Proceed.
Appellant has been convicted under section 15 of the NDPS Act
Yes.
and was sentenced to undergo RI for 10 years and rupees
Yes.
1 lakh. The aspect of the case is I am placing the judgment, my lord,
Yes.
that on the night of 21 to 22, February 94 night, the circle inspector Acquittal, ASI DD Naik, ASI Tigriya, Vishnu Charan Raut, OIC Boramba PS, RK Panigrahi, the USAP force were performing anti-docaity patrolling on Katak Narsingpur Road at Nuapatana, Durga Bazaar. On the night at about 2 a.m., they detained a tracker bearing number substances which came from Narsingpur side. At that time, one mini truck bearing registration number came from Athawad side, which was also detained for checking.
What is your case? What is your defense?
My case is after detaining the mini truck and the persons were arrested by the prosecution police officer, which PW8 of the
Yes.
witness. I will show you what the PW8.
PW, yes.
Proper procedure has not been followed.
Which provision is not followed?
And
Which are the provisions not followed?
the provisions which are I have collected decisions also.
Yes.
After seizing the materials, they have not followed the due procedure. That is my only.
Which provision? 52, 57, 42, which provision is not followed? And from the evidence, you show me that on facts, what is the evidence? Thereafter, you show me the law.
I am reading the PW8.
Yes.
Con question this it out.
Yes, I'm there.
PW8.
Yes, ma'am. Which para?
On such a, I was circle inspector at Vada on YC 294 night, myself.
Which relevant part you read? You can't read.
They find 6 gunny bags in the carrier of the mini truck, filled with poppy straws.
Which para?
At that time, finally it is running page 50 over.
Yes. Paragraph 3.
Zero for the
Here. The accused persons were carrying. That part you are reading, the top of the third.
They after seizing the document, the poppy straw.
Poppy straw.
Procedure followed. They have not that. That is that. So I am reading their procedure. The mini truck filled with poppy straw. At that time, the driver and the helper of the trucker were also present. As the accused persons were carrying the poppy without any authority, I seized all the 6 bags along with the vehicle and prepared a seizure list in presence of the witnesses, with these exhibit substances. I collected sample from each of the gunny bags and prepared 6 sample packets. All the sample packets and the residue kept inside the gunny bags
were sealed by using the seal of DDI, ASI of Hon'Ble PS. I kept the seal on the sealing wax as a sample and handed it over to Pradeep Kumar Behera, PWN. I returned the brass seal to Mr. D.D. Nayak, Pradeep Behera, acknowledged the receipt of the sample of the seal and the seizure list which is exhibit along with the signature. Investigation drew the written necessary myself at the spot. This is exhibit 3 and exhibit 3(1) in my signature there. I shared
57, according, then the 57 is complied. Madam, you do, better you do one thing, you prepare your, the points. Prepare the points and which witnesses have said what. You prepare a note, I'll put it as per your convenient day, then we'll hear it, because the sentence is very, see, 10 years or something. 1 lakh rupees, 10 years, is very serious case. It has to be done in that fashion. Which are the provisions according to you is contravened? And which procedure is contravened according to you? And towards those provisions, which are the evidences you want to rely upon? You just note it down, prepare a note, and then we'll proceed. Okay. Dixit, huh? When do you want, madam?
First week of
9th of September?
yes, madam.
9th September. 9th September. Prepare a note for me also.
Or 10.
10, no, 9th only. 9th. 11?
11.
Prepare a note
My lord,
for the prosecutor also, for me also. Okay. Next.
68.
68. It is 69.
Yes.
68.
Fine.
The accused are convicted under section and 8 of EC Act.
Yes,
Yes, Your Lordship.
yes. Yes, what is the offense?
Offense, under, conviction under section 7 and 8 of EC Act, in contravention of section 3 of Essential Commodity Act, read with clause 3(2) of Odisha Rice and Paddy Control Act order, Your Lordship.
Yes.
Your Lordship, there
What is seized?
seized of 40 bags of
Boiled rice.
boiled rice, Your Lordship.
14 bags.
40.
40.
Okay, 4.
Each bag is 100 kg.
No, Your Lordship, I'll come.
Okay, yes.
Your Lordship, the prosecution, according to the prosecution story, the OSI, South Kosia Police Station was investigating another matter, so and so, with an additional superintendent of police. In the course of investigation, in the said case, they detected a truck at about 11:20 p.m., Your Lordship. Kindly note this, Your Lordship, 11:20 p.m., 28/8 of 1992.
28?
28/8/1992, Your Lordship.
At
Sorry, Your Lordship.
timing?
Timing is 11:20 p.m., Your Lordship.
11:20.
Detected,
Okay.
Your Lordship.
Yes.
On the query, they found 40 bags of boiled rice weighing 100 kg. Each were loaded in the truck. The appellant number 2, Chintamani, was the driver, and appellant number 1, Balram, claimed to be the owner of the said rice, Your Lordship.
Yes.
On demand, they could not produce any license for the possession or transporting the same, causing the violation of section 3 of EC Act, read with the aforesaid control order, that is the Odisha Rice Paddy Control Order, section clause 3(2) of the particular order, Your Lordship.
Clause
3(2).
3(2) of order, petty order, huh?
Petty order, Your Lordship. Your Lordship, there are total 4 witnesses, they have been examined. Out of these 4 witnesses, 2 of them are the independent witnesses, Your Lordship, and one is the official witness. The other one, the PW4 is the
Who is PW1?
PW1 is, Your Lordship.
Chintamani.
PW1, Your Lordship, come to page number 23, claiming to be a businessman, a business only written.
He has witnessed that this Chintamani Sahu. Who is Chintamani Sahu?
Chintamani Sahu is, Your Lordship, the driver of that particular.
No. That is
Appellant number 2.
Appellant number 2.
Sorry, accused number 2. Your
Appellant
Lordship.
number 2
Yes, Your
was loading.
Yes, Your Lordship. Your Lordship,
At 20 on 28/8/92 at 2 p.m.
Your Lordship.
2 a.m. He was loading. He saw.
Yes, Your Lordship. My submission would be lie on 3 points, Your Lordship. The first thing, Your Lordship, the first point is the number of bags are doubtful, Your Lordship. Your Lordship, you come to page number 23.
One number of bags doubtful.
Number of bags is doubtful. Bags are doubtful. Bags are doubtful, Your Lordship.
Doubtful. Yes.
And also, there are discrepancies in timing, Your Lordship.
Number 2 timing this.
No, in first point, there are bags.
Number 2 point. You tell me.
Yes, Your Lordship. Timing and the weighment of the seized article, Your Lordship.
Weighing.
Yes, weighing of the seized article, Your Lordship.
Article, bags, rice.
Yes, Your Lordship.
Third.
The third point is that there is no clearance as to which notification of section 3 of EC Act has been contravened. There is no clarity. Only section 3 is saying that the accused has contravened section 3. That has to be a particular specification under which clause the accused have contravened the section, particular provision, Your Lordship. The third point is, Your Lordship, the informant and the IO. Informant and the IO in this matter are the same.
That is 4th point then.
Yes, Your Lordship.
You
That
said
is
3 point you have, now you are increasing 3, 4. Informant and?
Informant and the IO
And
in
IO.
this case are the same, Your Lordship.
Okay.
Basing on their statement.
Now, show me the number of bags doubtful.
Yes, Your Lordship. Page number 23, Your Lordship.
23, yes.
Yes, Your Lordship.
Yes.
PW1, Your Lordship.
What does he say?
He says, Your Lordship, on 28/29/8/1992 at around 2 a.m. A truck carrying the rice was brought to the PS by the police, Your Lordship. The first, in the first paragraph, Your Lordship. I was decorating some Ganesh pandal near the Satkocha police station. One Chintamani Sahu was the driver of the truck and the other accused was the owner of the rice. One rice bag was weighed, one rice, Your Lordship. One rice bag was weighed out of the hole and found to be 100 kg. Not
One
each.
bag, 100 kg.
One bag is 100 kg. Your
40
Lordship.
bags.
Your Lordship. 40 bags means we need to
40
calculate.
quintal.
40 quintals. But Your Lordship, one bag has been, not the each bag. Your Lordship, the accused Balram told that.
What, one bag and each bag, how do you distribute?
That is what the question before Your Lordship. One bag is 100, you cannot give the guarantee that the other bags will also weigh
That
around.
way you are saying.
Yes, Your
It
Lordship.
should have been each bag.
Each
contained.
bag, Your Lordship.
That way. Okay.
And also, Your Lordship, if you see, now come to page number 25.
Yes. Yes.
Page number 25, Your Lordship.
Read the relevant part.
The first paragraph, Your Lordship.
Yes.
2 a.m.
Mukuji.
46 bags.
2 a.m. At about 2 a.m., 28/29/8 of 1992, detected a truck. Your Lordship,
Yes.
PW1 says that
They were loading it.
loading.
Detect-
PW2 says detected.
It was
Your Lordship.
loaded.
Yes, Your Lordship. It was loaded with
46.
6 bag now.
40.
Yes.
40
Yes, Your Lordship.
it was earlier 40 bags. It's
40 bags.
It is overwritten there.
It was earlier, it is 40 bags. Now it is 46 bags.
The evidence is overwritten.
Yes, Your Lordship.
46 or 40?
Total 40 bags.
40 or 46?
40.
You come to page 25.
Yes, Your Lordship.
It is
46.
This is 46 written as the overwritten.
Yes, Your Lordship. Let it be 40 or 46. Maybe
No,
one
how
bag.
this-
Maybe one bag. But it is true that the one bag is only 100 kg.
But it is, see, you have whether it is 40 bag or 46 bag.
My lords.
Quantity has to be see because see,
Yes, Your Lordship.
PD order 3.2 is not complied according to you.
Aye.
Then the quantity has to be ascertained.
Aye.
The quantity is doubtful. 46 or 40. Eh?
46 bags of rice.
46 or 40 bag is doubtful.
Yes, Your Lordship. Now, accused Balram was the owner of the said rice, and accused Chintamani was the driver of the driver. He also says one bag of the rice out of the whole loaded bag and found it to be 100 kg, Your Lordship. That means the entire bag has not been weighed, Your Lordship.
Your case is neither the number of bag is confirmed nor
The weight is confirmed.
nor any evidence has come to show that each bag contain 100 grams.
Yes, Your Lordship.
100 kg.
Yes, Your Lordship.
That's what your case.
Yes, Your Lordship.
Okay, next point. Come to the next one.
Now, the next point, Your Lordship. Here, page number 27, Your Lordship. PW3.
Yes.
On 28/29/9/92, at about 1
Half an hour here and there to the
Fine, Your Lordship. Half an hour here and there, that shall not be taken into consideration. Fine. But Your Lordship, here also it says 46 bags.
where does it say 46?
The same line, Your Lordship.
Yes, 46 bag.
46 bag.
Yes, 46. Yes.
One rice bag was weighed and found it to be 100 kg.
They may say that one you read each.
Sorry, Your Lordship.
They may say one means read each. Each bag contain 100. But the 46 or 40, there is a apparent.
It is 40 bags, and how can it be 40 quintal? If it is 46 bags, there has.
Where is it written 40 quintal?
It is written here, Your Lordship, second paragraph. One of the rice bag was weighed and found it to be 100 kg. Both of them could not show any valid authority.
Yes,
for the
second paragraph. Second.
in quintal.
It is 40 quintal.
Quintal.
It can't be 40 quintal if it is 46.
If it is 46, how can it be 40 quintals?
It can't be 40 quintal. Yes.
Now come to page number
Yes,
29.
46 nahi, 40 lakhe to 40
But
bag.
everywhere you see. But in
Correct.
come
Wait, line
No, no, 40, 27.
So-
PW3 also says 46.
मत लागू सेटा सर
Second
40
line.
बोली
लागिले कौन हो आपण एविडेंस देखियो ना. Unless you say this printout is wrong. You check it up from record
69
whether it is 40 or 46. You say 40 quintal in 46 bags. Each bag contains 100 kilogram, 100 kg.
we do 3 then
Yes. Next.
Your
madam.
lordship, your lordship,
Meanwhile, you find it out
Your
whether it is
lordship.
correct or not. Yes.
and if it as 40 bags, 40 bags.
total 3 to 40 kindly see
It looks like 46. And
border कर देखो पूरा 40 हो
and PW2 is very
PW
clearly 46.
good time
My lords,
1 minute. Let it be clarified first.
सर 40 से देखा हो जैसे 40
अरे 40
से 3 टा सर 40 पूरा देखा हो देखो जोटा कि पूरा लिखी से 40 क्विंटल्स बोली भी लिखी
if you can see, take my record, it shows 46.
Pidol 3 kindly see Pidol 3 also
3,
Again.
okay. Second paragraph.
again
Police sees OR number so and so with 46 bags
सर
of rice.
सर 40 सर ये ऑनलाइन देखिल ता उठे बड़ा करी देखो 40 लिखा है
1 40. No, there is overrating.
সেটা
No, it's 46.
27 pace
Yes, just see 46 you have done. Somebody has corrected it. I don't know who has done it. Somebody 46 very clearly. Enlarge it, you will see 46. So come to you verify that, huh? And tell me the next point.
yes, your lordship.
Weight of the rice also you have addressed because it is
Your
each
lordship,
bag instead of each bag 1 bag. Okay.
Yes,
Lordship, my
one bag
only
to
point
लिखा है
is, even if it is 40 bags, out of 40 bags, 1 bag has been, and 1 bag was found to be 100. So we cannot clearly say that if 1 bag is, there is a difference between 1 bag 100 kg and each bag 100 kg, your lordship.
There you made your point, no problem.
Page number 29.
There should have been some evidence to show that each bag contains,
Each bag.
but all the witnesses are saying 1 bag.
1 bag and found it to be 100 kg, 1 bag, your
Yes.
lordship. Your lordship,
Yes.
come to page number 29.
29.
9.
Yes. Yes.
On 28-29, at around, I was OIC Sarkosia police station on that night, while I was going with additional SP to investigate a case, we found a truck coming from Anandapur, side loaded with the rice. I instructed the truck driver to take it to the police station. Balram was the owner of the rice and Chintamani was the driver. Your lordship, here the investigating officer, who is the informant, the OIC, your lordship, has not mentioned any time as to what particular time the truck has been detected, your lordship.
Okay.
But you come to the next page, your cross-examination, your lordship. Para 7, your lordship.
Yes. I saw the vehicle first time at 11:20.
11:20 PM, your lordship.
11:20.
On the road, and I was witness in the, your lordship, this is not clear. Confiscation proceeding. I do not know if there is any aid claimant of the said rice. Your lordship, here here the accused appellant's defense is that he is not the sole owner of the entire 40 bags. There are also 7 others, including him.
1 minute. PW, you read PW, which PW?
PW4, your lordship.
For the IO.
For the IO, para
IO at
1,
page, it's the page,
page 20,
para 7.
para 7, your lordship.
PW4, para 7, 11:30, huh?
11:20 PM, yes, lordship.
11:20 PM.
Yes, your lordship.
PM. Other witnesses?
2 AM and 1 witness saying 1:30 AM.
Witnesses 2 PM or 1:30 PM.
AM, your lordship.
AM, sorry,
Yes, your
AM. Okay, that also I understood. Next.
Yes, your lordship.
Yes.
Now, your lordship, the second point.
Hmm.
There is no clearance as to which notification of section 3 of the act has contravened, your lordship. For that, your lordship, I have a judgment of relevant
Where is
judgment.
where is that provision? Where is
The provision,
You
your lordship, in the judgment cell.
show me the provision first.
Yes, your lordship.
Show me the provision. 3(2) of Pedi, what is that?
Your lordship, clause 3(2) of Odisha Rice and Paddy Control Act.
Give me that provision if you have.
Your lordship, pardon, I don't have.
And I'll imagine everything then.
No,
It's 10 ne sir likhichandi boda.
Page
10 of the judgment sir likhichandi.
Okay, let us.
According to clause the
But what? Let us read the provision. What the provision says. Why don't you people read the provision and come?
your lordship, I have the soft copy of the provision. I can go through it, your lordship.
So read it out at least. Read it out. 1 minute. Read it out. What is the requirement in that?
Yes. Your lordship, please. Subclause 2 says, for the purpose of calculating the quantity of the rice sellable under subsection 1, a quantity of paddy shall be deemed to yield rice at extraction rate of 67% in case of the raw rice and 68% in case of the parboiled rice.
What did I read? 60?
67% of raw rice and 68% of in the case of parboiled rice.
331 rahita.
Completely read 60. Read it once again.
Okay. Clause 2, for
Hmm.
the purpose of calculating quantity of the rice sellable under subsection 1, a quantity of paddy shall be deemed to yield rice at extraction rate of 67% in case of raw rice and 68% in case of parboiled rice, your lordship.
Okay.
Your lordship, kindly see page 17, your lordship, regarding the bags.
No. Let us go one by one.
Okay.
Now, how will you deal with this? Which with this?
Your lordship,
67% of
your lordship, there is no clear evidence as to how many percentage of boiled rice has been. There is
para 6 of the
Para-
judgment you come.
Yes.
According to clause 3A of Orissa Rice and Paddy Control Order, a person found in possession of the rice or the paddy taken together exceeding 10 quintal inside the state of Orissa is deemed to be carrying on business of the dealer unless the contrary is proved. The statutory presumption according to the control order has to be rebutted by the accused and the burden lies on him as per section 14 of EC Act. But you are saying 2, but the judgment says 3A of Orissa Rice Control Period. You are reading some other provision.
Your lordship, here it is mentioned 3(2), your lordship.
Violation is 3(2).
Yes, your lordship.
Where is that
6,
violation?
page 10, para 6.
Page 10, para
6, your lordship.
6 3A. Para 6 3A this.
Maybe some type mistake, your lordship.
Para 6 it is 3A. Which petty order is violated?
Page 17, your lordship. Jodha I'm quoting 3 accused statement. Admitted that I'm 8 jana nowthulu 40 bags.
I'm on something else. What I'm asking is which petty order has been violated, which lead to section 7, section 3 and 7.
Here it is mentioned, your lordship, Odisha Rice and Paddy Control Order 1985, your lordship.
But which clause of that petty
Your
order?
lordship, it is
Section 14 of the EC Act.
judgment is 3(2) ଅଛି
3A.
ଅଛି ନା
See, para, if you read, but this judgment says here is something else. But it is 3A. In fact, if you see the what you call the soft copy,
yes yes
just see the soft copy, para 6. Para 6, it is 3A. Who has made it? 3(2).
Lordship, it is 3(2).
No. Soft copy, just see. Soft copy in the computer. 3A. 3A. But here it is 3A. Come to the paper, appeal paper book. Appeal paper. Appeal paper. Don't read the record. Appeal paper, impugn order. Just see. Appeal paper, impugn order. Which we type. Just see, take it. Give it. Read both of you. Para 6. Read para 6, both of you. Just see, Mrs. Maharana, Mrs. Das, just check it up. The file which I have given.
It is mentioned 3A.
3A.
Yes, your lordship.
Then
But here it is, your lordship, 3(2).
typing, maybe the type copy. It should be 3A then. 3(2) then. Because the original record, item 16, right? Let us see. The paper book says 2A. Let us see the judgment here. The original judgment. Let us see. Where is the original judgment? Original judgment. It should be 3(2). It should be 3(2), not 3A. Wrongly typed. Anything to say?
Regarding the 40 bags, your lordship, kindly see the 313 statement of the accused, page 17 yours. Question number 2.
Question number
2.
2. Yes.
It transpires from the evidence of Pedal 4 that you and Chintamani were transporting 40 bags of rice in the said truck without valid permit or license. What do you want to say? 8 ଜଣ ନେଉଥିଲୁ.
That makes your case worst.
Sergeant से तो admit कर देले ना 40 bags.
Admit नहीं, if the PW2 is saying 46 bag, how can you put something else to the accused in 330?
In a seizure,
330, whatever incriminating evidence has come.
Your lordship, in seizure it is 40 bags is written.
You see, it's all typing problem. Is it? Just see, I'll just show you. Take it.
Your lordship, kindly see exhibit 1, your lordship. Exhibit 1.
But take it, what will I do with this?
Sir, could a Pedal 3 da?
Take it this.
I know that that's what they call it. Sir, 3 and 2 it I very confused.
You have to read the evidence, whatever there is record.
Again.
I can't presume something. If it is 40 bag or 46 bag, it should have been put to the accused. Make your
40 bags इतने से ऐसे पहुंचल. Sir, जो exhibit 1 सीजर लिस्ट देखले क्लियर है जो कितने सीजर साइन करछन ओवर साइन ओवर देयर.
Very सीजर लिस्ट, let us see.
सीजर exhibit 1 lords.
It appears something is manipulated in the record. Looks like overwriting and all, everything is happened in this case.
Exhibit 1.
Exhibit?
ओडियर सर पूरा 40 এটা কি সাইন করছে 2 জগন্নাথ
Exhibit 1, huh?
1/2 is my signature.
Exhibit 1, yes. चावल नहीं है. टाटा ट्रक पड़ा है जैसे 40 हाँ 40 ब्रैकेट 40 ब्रैकेट लिखा है. बस्ता सुना चावल
नहीं जाऊता बड़े सातो को जंगल रास्ता रे চেক করা দিবা তথা লাইসেন্স
Very clearly 40 is
40.
written, but
40.
the witnesses are saying something. It is overwritten. Who has overwritten? I don't know. You have to verify and give me in writing. Give in writing. Because it appears some manipulation is being done in the record itself. Record itself. Then check your paper book. You can take my paper book. The paper book says something else. You both of you file a small written note. Small written note. And he produce the petty order also.
Yes, sir.
3-2 or whatever.
Come up
3-2.
with support judgment.
Yes. And with along with judgment.
Yes.
Judgment result, the parties are directed to file written note of.
Grateful, Your Worship.
Within, don't delay it within maximum by 1 week.
Yes, Your Lordship.
Then- Yeah. Item 80. Eight zero. You file. Yes.
My lord, last officer.
Only appellant number 1 is there, huh?
No, my lord. Appeal number
Both of appellant
2 has expired.
1
One
and
and
2,
three.
1 and 3, both are there.
The name of that is.
I have just forgotten. Just let us see under what exactly.
Yes, my lord. The correction 372G.
3?
376 2G.
376.
I filed my note of argument, my lord. Here, my lord, the sentence
Note of argument you have given?
I had given.
Where is that? Yes, note of argument. Yes.
My lord, EFI has not been conducted, and the prosecutrix victim, she never knew these people earlier. The FIR, she says that by the features, which my lord remembers now that case, and she was identified these people
First time in the court.
through the local aids first, then first time in court. And on the last occasion, my lord was pleased to ask my learned friend as to on what basis the identity was established as culprits.
Oh, okay, I remember now. I recall that. See, the FIR there. Yes. Take it. 1 IU, huh? PW
35.
Yes. Yes. On the CORAM report,
Indian had identified accused person in connection with the occurrence of this case.
case. He could made out a case. If you want to dislodge him, then you have to make out a case. Yes.
83.
83. Yes. Ready. Ready. Not ready.
So 83, as disclosed in senior advocate Mr. Dalu sir, then he is talking about that accused was not released from the jail for his information.
3 months.
3 months, okay. Yes. 5 witnesses.
Yes, sir.
Yes.
PW 5 to 3, all are supply inspector.
Okay. Who is the independent witness?
Independent PW 1 and
Let's see, 1 then 3, 1. PW 1 and 4 independent.
yes,
PW 1 and 4 independent. Yes. 3. Do you have the statement with you? At the end of the don't you have? You have read the evidence or not? You read? You don't have a copy, how do you read it? You have not read it, then read it. Take out the soft copy, read it. Take out the soft copy and read it. The counsel for the what is your name? You have to argue. Huh? What is your name? Mona Lisa Monti, the counsel for the appellant submits that he doesn't have the copy of the parent court record, since she may be supplied the same. Mrs. Monti is permitted to obtain the soft copy of the Supreme Court record. Leaves the matter for argument well. 4th. Take the soft copy right now. Okay.
92.
And while coming, you read the provisions also.
Yeah.
Madam, provisions, the control order which was violated and everything, all the provisions, get ready with the provisions and all, prepare a small note and come. Okay. Yes, take it.
Your 90. Your option, pardon me, item 90. I have applied for paper books since long. And they haven't supplied. If your lordship kindly orders for that, because
Okay, so you take the soft copy. No problem. You have pen drive now. Take it now. Soft copy. You can take it. Huh? Yes. 92. Huh?
Yes.
Good. Yes.
It's 325 and 34 minutes.
325.
Yes, 34. RI for 1 year, fine of 500 rupees. RI for 1 year. There are 2 appellants.
Come to weekly. Come to the year.
That's PW1 lots.
Yes.
Before that, I will just bring to your Lakshmi Sora that FIR case 34. It's a case, Lord, the informant was assaulted by the appellant, Lord, in front of some independent witnesses and villagers that are well reflected in the FIR article and the 34th page.
But not examined. Maybe.
Yes. None of the eyewitnesses, as per version of the informant, has been examined. That's it. Kindly mentioned some names.
Yes.
And this is a assault by one Kazurian stick, lords. It's a young katho, say related, young Kazurian stick. There are injuries, lords. Previous injuries are also there.
এই সময়তে ভীমেশন বারিক বলভদ্র মহাপাত্র সিদ্ধনাথ সাহু রথি বারিক
ଓ ସାହିର କେତେକ ସ୍ତ୍ରୀ ଲୋକମାନେ ଉପସ୍ଥିତ ଥାଇ ଏସବୁ ଘଟଣା ଦେଖିଛନ୍ତି. One of these persons, my lord, has been examined. On PW4 has I come.
One minute.
It's a nice effort. Yes. PW4 is like the prosecution is one of the IU plus PW4. But see,
Out of these named people.
no, no.
PW4 is eyewitness, huh?
Yes. But it is not named Millard there.
Not named
In the FIR. And here, I do not know anything about the occurrence. Page 50 relevant, PW
Page 50.
Let's. Says, one, I know the accused persons are Mapatra, who are my neighbors. I do not know anything about the occurrence.
I do not know anything about that.
Yes, that's it. The second aspect is
From
was declared,
but no, was yes, no, you read it far.
APP.
It is not a fact. Yes, that I have stated before the IO that
Not a fact, yes. That I know that on 16 to 99 at about 7 p.m. in the evening with hearing preliminary in the Danda side,
Not
I came out and find that Kesavan Mahana of my side and Chakuraswamy, both are appellant. But assaulting is not a fact with the same narrative.
yes, only one independent witness. Injured has to be.
PW1, let's see.
Yes, PW1 injured.
Yes, sir.
Injured. What does he say?
Yes, sir. Here I will bring to Rasif's kind notice not the place of occurrence, para 3, page 3, line 3. Yes. That is not to my inner courtyard. Case is my lord when the informant was doing some reading that Bhagavad.
Chakrudhara Swami.
Yes.
Chakrudhara Swami came to my inner courtyard
And called me. So that is my lord to this prosecutor, that is the place of occurrence. Inner courtyard. That I am junior to Larson notice. The cross command also says, he has said page 44 and going to relevant word. This occurrence took place in the inner courtyard. Correct. We are this page 44. I'm only bringing to us the place of occurrence. I'm going also, I shall also go to PW2 and 3, also to PW7. So for place of occurrence is concerned. This is inner courtyard. Line number 4. This occurrence took place in the inner courtyard. But PW7 has said it is on road, the IU. So, my lord, what I even PW2 and 3, their wife and son of the injured.
All of them say inner courtyard.
Yes, 2 and 3 versus and see PW2.
PW2, okay.
Wife, my lord, 30 mark.
Enter into our courtyard.
Yes.
Answer into our courtyard.
Yes.
And called my hand.
Yes.
My husband came over. Came near the gave from that. So my husband replied, "This is not so. So
And 3
PW1,
was the injured.
PW2, and PW3.
Yes.
PW2
son.
And 3.
Yes, 3 the son of the
3.
informant.
Place of occurrence.
Place of occurrence, plot, page 48, came to our inner courtyard
Occurrence.
and called me other paragraph line.
Inner courtyard.
Yes. My father was reading Purana at that time. The accused persons came to our inner courtyard and called my father.
IOPW.
I do PW7 words.
What he says?
Road. That's only so far on clarification of my learned friend. So far this, yes.
PW.
My 7 words.
7 years.
7. PW7 words. One million, I will do more page 55, PW7. That these two appellants, my lord, during course of millions.
No, first,
The page 56, let's cross. Cross examination by defense.
which color?
This spot, 4 letters. This spot is the road situated in front of the house of the informant. The next line is also from your, I didn't find any gloss stain mark on the spot. There are building injuries. So now my submission will be lot when place of occurrence is also editing lot. The prosecution and so far this improved judgment will not basing on this will not and that apart will not there are also previous injuries of the informant, also bleeding injuries. So will not this blood stain arc will not blood stain cloth is there will not seizure. So for blood stain arc is also come that is also not I think get will not in the entire. And so
Injuries are there.
Injuries are there.
And he narrates the injuries.
Yes.
What is the weapon used?
Weapon that one Carnelian stick blood. When how cut to what we call how cut. Jamro the body.
Who is the doctor?
Doctor is not PW 5 question. 5.
The doctor.
On 16 to 99, I was the assistant surgeon at District Headquarters Hospital, Puri. On the same day at 9:30 p.m., the police requisition I examined Dr. Lacerated wound was including one by post or big raw words. Then lacerated wound again, 3 BBK is there, like an abrasion is there. Abrasion. Here we have medical evidence is not supporting that previous injury. The 325 has come.
Where does he say that he is? Where from the court got this grievous injury?
And that PW 8 has revealed that there is an X-ray fracture of the eye to luna. PW 8.
No. The doctor also says, I have not suspected any injuries to be complicated with fracture. He says that.
PW 8 is another doctor who has also.
18 another.
PW 8.
8.
Radiology specialist.
What does it
that day on police situation, I have gone to the X-ray of the right wrist with 4 registration on that. And after the X-ray, it found that there was fracture of lower 1/3 of sac of right side right X-ray plating.
There is a fracture also.
Yes.
Then come to the map.
Yes.
Map,
Yes.
you see,
Yes.
X is the spot.
Yes.
Where is the courtyard? Where is the courtyard?
It's the occurrence house of accused. Spot is the cross one. C.
That's their house.
C.
C is the courtyard.
Yes. C is below the cross one.
House of complainant.
Yes. House of complainant is C. Courtyard is just in front of on road.
Then it's correct. Road it has. Where is the doubt?
What I say, Lord, what is being told at notice, PW 7 will not be say out of it, it's well corroborated on this spot.
If the map shows,
Yes,
it is road,
yes.
immediately after the podium.
But I am notice that so far PW 1, 2 and 3 are concerned.
They say courtyard.
Yes,
They
yes,
say
inner
courtyard.
courtyard.
And at the same time, all of them are saying that he went out.
Inner courtyard, what I try to learn that inner courtyard, I place 1, 2, 3, but 7 corroborated with the spot map lot that comes out of the house.
Then the plot might not be that much.
Yes, so far my submission will be, further submission will be, PW 2, 3 are all interested with it. Their credibility is not when there are, as for FIR, there are other available at the time of occurrence.
That you have a good point.
And then one will be why
In the FIR, the name witnesses are there. You have not examined. Some stranger who interested witnesses you brought. Those are nowhere.
Describe the people one, who is the injured person?
Here is there. So why the other witnesses named witnesses?
Injured is the best witness.
injured is might be not, who is the wife person?
Injured type,
Injury is best, but why have you examined the worst witnesses? 2 and 3.
2 and 3 are the
You
wife
spoil your
and
case.
wife and son, and in the
Named witnesses are there. You could have picked up one. Instead of doing it, 2 interested witnesses, you introduce their witness. Create doubt in your own case.
There's
the problem.
Then so far as we got this, this PW, I also said we got this, both the appellants and lot, they surrendered during course of investigation. And they stayed appellant number 1 for 21 days and released on bail.
1 minute. Let's figure one, let's read here. What kind of is in a stick, what which stick you're talking about?
Casuarian people that seizure is just that is what we of how
Then this is SRO in case.
yes.
Chocolate yes, assault me. Yes. Chocolate assault to my head. Head. This is by what is the what wound?
That Jamu also cutting down.
So
मोठा मोठा सुतार
No right side.
so then injuries are
Yes.
this is chocolate assaulted to my head.
Yes.
And there are cases also right hand back.
OS
And
other
other
cases.
So far corresponding.
And the lungi and gamcha, that has been brought. It was examined.
Yes, I am only saying that so far that's for art is concerned. Bleeding injury is not throughout the case of prosecution, that is bleeding injury. And so far as this injury will not happen,
All the things giving concession.
yes. EW one and doctor's evidence. But EW one, which is corroborated, PW five doctors, nature of injury, Lord. Because but this, no, Lord, so far as this fracture and other things, Lord, that is also can be done with injuries. Case 52, I am not.
8 injuries are there.
Yes, you should, EW five. So far as this, EW one says, Lord. That all means one glass, so only there one scalp. Scalp is there, but
We say that.
but there's a fracture on left.
Chakradhara is given the.
But the PW 8 has said me or that previous is concerned or that X-ray plate is concerned PW 8. They said that the right.
Very difficult, except the eyewitness thing.
Yes, we won't have that. Another aspect about conduct of the appellants conduct what I say is during course of investigation they voluntarily surrendered and they were in custody for 21, 22 days respectively. Thereafter they were released on bail. That is all reflected in the judgment itself also. That is
Last.
Page 30, paragraph 20. And
13,
yes. 30, paragraph 20. So, period of custody.
It is found on the case of
Yes.
jail custody from 2 each other jail custody from application.
And so far as not being arrested and surrendering, that you will kindly get it from PW 7. I was the police. 855.
Surrender.
Yes. Both the accused person surrendered in the court during the investigation as well as frequency judicial custody. PW. Yes.
What was the age of this person?
At that time, I think 2003, they say, appellant 1 is 29, so
24 and 26.
but at the time of filing, it is 29.
29, 31. Other player, 20.
No, that's the basic.
51, whatever. 51, 62.
This is the fix. That is also technically surrendered on.
Yes, that's good. And I have one more thing.
One minute, let's find out.
This one, whatever. This one, so that's over. Yes. Para 20, yes. I was calculating my 10 days. Comes to 22 days. Chakradhara is 22. Chakradhara is going to ask for clear.
You must be. Yes. Yes, 21 days under one.
Yes. One submission, more submission. This re-examination of PW leak. Review by this Mura. That signifies there is a fracture. It has indication in previous injury. But it has been not noticed by the PW 6 was examined and injured and 8 injuries she has noticed.
He says that there is no, there is no fracture also, you see.
Understanding of the injury cause. Subject to correction of the class. PW six is the injury. And this aspect, again, IUPSS were not examined. Again, after this, because PW eight has come and stated of the radiologist deposition is required, was required there. The treating doctor has left on 8 injuries. That is one of the submission. Talking about PW five, what? 5 with 8, PW 5 and 8. PW not suspected in fracture. Opinion by PW 5. But a X-ray was conducted and PW 8 reveals not there is a fracture. A radiologist has given opinion to the X-ray after 2 days. There is no explanation about why it was skipped by the doctor. Why it has not been also explained here why it has been not by the treating doctor. But this injury is concerned.
You have not asked me
There is also no explanation, Such significant injury was missed by fast examining doctor. End of medical evidence is always not has to be, it has to be in chain lot for 6. I think that I will take you out to 6 minutes. This is
Lungi and all. But his testimony is not even put to.
Yes, that was the 22 days.
Appellant number 2 is here 20 days, appellant number 1 is 22 days.
I'm checking up, they have filed they have signed the Bakal plan. My friend was also there. But TCI is concerned. And here also, on 25/2003, the Honorable Court has also given this to that IA, released order number 2, 25/2003. Yes, yes. Thereafter also replied by this appeal.
Yes, there is no creating and building.
Yes.
Fine.
Fine, doctor. Doctor was examined on the same day.
Right. See, minor variations are there, but. The point is that witnesses is not examined, but that doesn't mean that the witnesses who have examined will discard them.
This can, yes. When is the injured, the pedal one can.
We'll see. We'll be fine. Because they are in their case. Incident taken place in 1999.
Exactly.
I was information that the appellant is there. So his information is reported upon.
93. What was the date? 38. Date. Indian Council for the permits 93. Submits that as per the rural instruction. The sole appellant Suvat in the Korea is already expired. In that view of the matter, the state council is directed to the instruction. Leaves in account 4. Yeah. Talipur. What are yes, sir. Yes, sir. Which item, sir?
Maybe. Or here the appellant. No.
Yes.
I have a matter that is 1999. Today, thinking that
And there is a low adalat also, free low adalat. 445. Give a date, you tell me. Last matter I'll see. I'll hear Mr. Mishra.
I'm suggesting one.
Yes.
If your lordship will my case may be treated as first hearing matter, I will complete it.
Second person. At the top.
But it will take some time, that's why.
What is the offense?
498-304B, 7 years punishment.
So the evidence of the witnesses who alleged it to be placed, whether there is contradiction or consistent.
But if you prepare a note, your junior can prepare a note.
Prepare a note.
So that will be easier. Waste much time. Give advance copy to them.
In advance copy, I will.
Yes. 19.
But here the appellant says the trial will charge under section.
Yes, sir.
In charge of 457, 376, IPC and 3 of the STSC Act. Now the appellant faced the trial. He has been acquitted from the charge under section 457 and 376. STSC Act also has been.
No, how many accused are there?
Only 4.
But he was not well. There is some report.
Yes, he was not.
See, the report is up for 2000 July. He was bedridden or
Yes.
something.
His brother is also.
Not good due to undergoing a treatment, paralysis.
Yeah.
That is bedridden since 5-6 years. Medical treatment documents of appellant is attached.
He was 40.
Now, he is a paralytic person. What do you do?
No, but my submission is initial charge was 457, 376 and STSC Act. He has been acquitted from those charges. He has been convicted under section 352, 451.
451.
And sentenced to 3 months in total.
I will give PO because of his health condition.
Yes.
Because of see the health condition. Paralytic
Yes,
photography is also.
Yes.
Where will you send this man? They see the photograph is so easy. As it is, God has penalty.
I was talking to the trial court lawyer also. Condition is best.
Because it's a terrible condition. So, initial charge is charge was
457, 376 IPC
You are charged for 1 minute and just note down. That Mr. Mishra, counsel for the submits that the sole appellant was charged for under section 457, 356 IPC. There is
Section
and
3.
section 3, 1 XII of the SC the SC. However, by the impugned judgment and order dated 19/12/2006, the appellant has been acquitted from the charges under section 3(1)(x)(1) SC as well as from which are 376.
Yes, 457, 376, and 360 said he has been acquitted. 352, 451.
Convicted under 457, 376 IPC. However, the appellant was had been found guilty of offence under section 352, only 451 IPC. And accordingly, the appellant has been sentenced to undergo
Under section 451, 1 month, 352, 3 months.
3 months.
No, sorry, the ultra. 451, 3 months, 352, 1 month.
1 month. 1 month. No fine.
No fine.
No fine. Has he undergone any time?
I think most. Much more. He was arrested on cell. The bail bond release will be July 2004.
No. Let us see. Arrested. Just we'll see that. Final form. Let us see. Final form. What is the name of this man? Damburu Dara. Arrested on 9/12, 7/12/2000. It is written 9/12. 9/12/2003. Forwarded on 10/12/2003. Bail bond. Bail bond. In order. After impugn order, that's next. I think he filed the bail bond from 2nd July 2004. So he remained.
After spend all the, because initial charge was 376. Only for that
he was released from custody on 2nd July 2004. Therefore, by the order dated
19/12/2006.
I mean, I'm waiting. By order dated 29/7/2025, a report was sought from the local police regarding the well-being and whereabouts of the appellant, and the persons were through the report. The IIC Tentuli Kunti has filed a report dated 36/7/2023 stating that the appellant, although is surviving, but his health condition is terrible. He is undergoing a treatment for paralysis, and he is bedridden since last 5 to 6 years. 6 years. Regarding it to the custody is already undergone, and his physical condition, Mr. Mishra, that is the counsel for the appellant, submits that he would not press this repeat insofar as conviction is concerned, and confine the argument quantum of sentence. He further submits that from the record, it reveals that the petitioner, the appellant has already undergone the period of custody, awarded against him, awarded. Therefore, nothing survives in the setting, according to the opinions. This one. Very simple, what is it?